Hello, my name is Attorney Dada London, and I hope this video finds you and your family well. I trust that you guys are practicing proper social distancing, you are practicing proper hygiene with frequent hand washing, and you are doing your part to reduce the spread of COVID-19 and or the coronavirus. I did want to take some time today to talk to you guys about the Emergency Paid Sick Leave Act, which is a provision of the FFCRA, or the Families First Coronavirus Response Act. And basically what that act does is it requires that certain employers provide employees with paid sick leave related to the coronavirus or COVID-19. And when you think about the timing of it, it's completely relevant and appropriate. You have engaged your staff that was either on furlough or unemployment. Hopefully some of them were able to work remote and you were able to maintain them. So you spent time engaging them, you spent time influencing them, inspiring them. You've created now a safe work environment for them to return to. However, there is a possibility that they can become infected with the virus, and what happens there, or what happens if they are caring for someone who has been contracted the virus. And so we'll spend some time dissecting the nuances of the provision of the act to help you understand and be ready to take care of your team and your workforce. So the first question is, who is a covered employer? And the act covers private entities that employ fewer than 500 employees. It covers most public employers or public agencies. There is an exemption, and the exemption kicks in where there are 50 employees or fewer. For the exemption to kick in, you have to show that the requirements to pay the leave would jeopardize the viability of your business as an ongoing concern. So you would put forward different financial information or different harms that could be caused from a financial perspective to your organization to be in compliance with the act. Covered employees under the act is going to be fairly straightforward. So nearly all employees will qualify. And so the employee will be as defined by the Fair Labor Standards Act. So who would not be included in an employee would be independent contractor. However, based on the work that's performed, if you are designated as an employee, then you will qualify for leave under the act, so long as your employer is a qualifying employer. So pretty straightforward here from an employee perspective and being a qualified employee. So there are going to be two types of qualified leaves that we're going to deal with. And the first type of qualified leave that we will deal with will be a leave that is specific to the individual or personal leave. So in effect, there's something going on with the individual. For example, an employee is subject to a federal, state, or local quarantine order or stay-at-home order, some type of isolation order as it relates to COVID-19, that will qualify for a leave. If an employee has been advised by a healthcare provider that they should self-quarantine, that will also qualify for a leave. Where an employee is experiencing symptoms that are similar to or related to COVID-19, that too will also qualify for a leave. And then one of the qualifying categories that it's important to note, these are going to be scenarios where the employee is unable to telework and they require leave. I think it's important to note that, they're in a scenario based on what they do or the job function that they perform. They are going to be unable to telework and therefore, under those three criteria, be eligible for personal leave. And then the second type of leave that an employee is going to be eligible for, like the last one that was personal, this will arise in a scenario where they're caring for others. So again, the qualifier is that the employee is unable to work due to COVID-19, and they're unable, based on their job functions, to work from home. If they're caring for a son or daughter or someone that reasonably falls under the expectation that this particular employee would be responsible for caring for them, they're likely going to be eligible. And I would recommend that you don't, from a litigation perspective, try to hang your hat on challenging whether or not the person that they are caring for falls into an expected individual that this particular employee is responsible for taking care of. You're probably going to lose there. It's going to be a son or daughter or someone reasonably expected to be under the care of this individual person, whether there's some type of incapacity, maybe it's an elder parent. But the qualifying criteria, again, is going to be COVID-19 related. So you are taking care of a son or daughter who has symptoms of COVID-19. You are taking care of someone who is required by the federal, state, local municipalities under some type of stay-at-home order or quarantine order. If someone that you're caring for falls under the criteria where a healthcare provider recommended that they self-quarantine. And this one is going to become increasingly more important as we have employees coming off of unemployment and furlough and going back to work, where your child care provider closes due to either an outbreak of COVID-19 or symptoms related to COVID-19, where an employee doesn't have appropriate child care because of COVID-19, they too will qualify for leave under the Act. Okay, so we are very close to putting it all together. You are a qualified employer. You have a qualified employee under the Act. They are taking leave that qualifies. Either it is personal leave or it is leave for the care of another. First question you should be asking yourself is, what is the duration? The duration of the leave, where it is personal leave, is going to be, for a full-time person, 80 hours of leave. And for a part-time person, it's going to be the number of hours on average that they would work. The pay is going to be that of their regular rate of pay over that time period, or minimum wage, whichever of the two is higher. These are capped. So the cap for the pay is going to be $511 per day, and in the aggregate is going to be $5,110 over a 2-week period. As it relates to the care of others, the rate of pay is going to be 2/3 of your normal rate of pay, and it's going to be a cap of $200 per day, and in the aggregate over a 2-week period, it's going to be a cap of $2,000. Now, For the care for others, the time period is longer, so you can actually be out for a period of 12 weeks on average of 40 hours a week. But again, the pay rate is going to be lower. And so that is the duration and the pay caps. Here is some exciting news for the employer. Firstly, the act puts you in a position where you're allowed to and able to keep your workspace and work environment safe. It allows you to keep your employees safe and allows them to look after their families, which I think most employers like yourself will state. But that's an exciting thing, and it's the right thing to do. Some other exciting news for the employer is that there are tax credits. So covered employers qualify for a dollar for dollar reimbursement through tax credits for all the qualifying wages that are paid out based on employees taking leave under the act. Now you want to make sure that the leave qualifies. However, dollar for dollar is going to be matched. There's also tax credits that will be able to be applied to maintaining their benefits under the act. So there was a scenario where you kept employees' referral load, but you continued to pay their benefits. There's some tax credits associated with that. It's important to note that there's a notice requirement. So you must post in a conspicuous place the act for your employees to access it, read it. It's also important to note that this is protected leave. So there's a prohibition against discrimination, discharging. Anyone that engages in this activity or taking this particular leave is going to have protection. It's a prohibited or a protected act, and you cannot discriminate or interfere with someone's use of the leave under FFCRA or the act. It's important to close out with the length of time. So this provision has gone into effect April 1st, and it will run through December 31st, 2020. So it went into effect April 1st, 2020. It runs through December 31st, 2020. So through the duration of the remainder of this year. And it doesn't allow for anyone to, who perhaps would have qualified in March, they're not allowed. It doesn't take into consideration previous qualifications. And so everything is going to be forward-looking. At the moment, there is no amendment to it. So I would say stay tuned for that. However, unless something changes at the moment, this act runs from April 1st through December 31st, 2020. I really appreciate your time. Really appreciate you guys joining me. Hopefully you learned something. There's going to be more videos for you to look forward to in the future. Feel free to email me any questions you have at dlondon@thelondonlawfirmllc.com. Thank you. Take care of yourself. Take care of your families. And take care of your teams. Look forward to talking to you soon. Peace and love.